and see if Jessica has any questions for me that came in.
Yes. First question, if the union covering certified employees negotiates this into their contract, does that then also apply to certified non-union employees?
Yes, it does. So if a union, any union in the district, well, any union that relates to the school in that district, it doesn't help you if the police negotiate in. But if any union of your school employees negotiates in, then certified employees who are not unionized will be covered as well. Certified employees who are members of a different union would have to wait for their separate union to negotiate.
Next question, how will this be shown on the employee's W-2?
So you want to talk to your payroll provider about that. There is Jessica, do you remember, is it box 10 on the W-2 that we encourage people to look at, to write
Oh,
it in?
I don't know the answer to that, but I will research it so we can put it
Yeah,
in the Q&As that we send out.
we have it as an FAQ on our website, and I just don't remember which specific box. It is not mandatory, but we encourage you to use, it's like box 8 or box 10, and most payroll companies do this where they specify Connecticut paid leave, and that's where it gets shown up. That's for the contributions. For benefits, benefits that we pay for medical leave, including pregnancy, are not taxable. If we pay benefits for a caregiver leave or qualifying exigency or bonding, then the worker will get a 1099 from the paid leave authority reporting those benefits.
The next question is, why do we need to provide the time employees take in fractions to the paid leave authority?
So we don't ask, I'm trying to think of what forms that question. We don't ask how much employee time the employee is taking in fractions. Federal FMLA and Connecticut FMLA say that if an employee is on an approved FMLA leave, they can use the time in the smallest increment allowed by their payroll system. But in no circumstances can an employer require a person who's on approved FMLA leave to use time in more than 1 hour increments, right? So if your payroll system tracks time by the minute, you can say, okay, we're going to do it in 15-minute intervals. If your payroll system tracks time in the hour, they can take time in the hour. But if they're on an approved FMLA leave, you can't say, oh, you have to use it in 4 hours, which is different than what I mentioned at the beginning with paid sick days, where you can be like, oh, bargaining agreement says they have to take time in 4 hour increments. That's fine if it's just paid sick time, but if it's FMLA, your obligation under FMLA is to allow them to use it in smaller increments. You will not tell us that at all. We don't get involved with that. Your employees will report to us when they're out of work. And if they're out of work on an intermittent basis, they will tell us exactly how much time they're out of work and we will pay them. But we don't get that information from you.
How is the 3 months of employment defined? Is it continuous?
Yeah, so for Connecticut FMLA, the 3 months of employment is defined by Connecticut DOL to include any time that you've got an employee who's on payroll or receiving benefits. So like if you keep them on benefits, that counts. And they say it's 13 consecutive weeks. Um, it did change for the school employees. And so it just says 3 months over the 12-month period. I have not seen anything from DOL to clarify whether those 3 months need to be consecutive or if because it says 3 months in a 12-month period, it could be non-consecutive. But we have to see what DOL says about that.
Can the contributions be paid per payroll period?
They can. We will accept the money however you want to send it to us. Most employers and most payroll providers want to send it to us on a quarterly basis, but it is possible for you to remit that money to us each time you issue your paycheck.
Will Connecticut Public Schools need to designate a qualifying leave as both federal and Connecticut FMLA? The reason I ask is if we don't, will that mean the employee still has the opposite available?
Yeah, a great question. You're gonna want to, right? Like, I'm not gonna get into whether you're legally required to, because there's a whole lot of case law that's really under the Connecticut DOL's and federal DOL's jurisdiction. But I will tell you, as an employment lawyer, as an employer, as someone who does this work, you're gonna want to. Because if you don't, you run the risk of an employee claiming that you interfered with their rights because you didn't give them clear information. So if an employee is eligible under both federal FMLA and state FMLA, and the reason for leave qualifies under both federal FMLA and Connecticut FMLA, you will want to designate it as counting against both federal FMLA and state FMLA so that you don't run the risk of an employee saying, hey, you never told me my Connecticut FMLA was being drawn down too. I thought I had that available to me. You know, you materially interfered with my rights. So you're going to want to do it. But you should know that if the employee is eligible for Connecticut FMLA, but not yet eligible for federal FMLA, say they've worked for you for 4 months, but not 12, they're only drawing down against the federal FMLA and they're only drawing down against the Connecticut FMLA. Their federal rights are untouched. If the employee is taking leave to care for their grandmother, that's available only under Connecticut FMLA. They're only drawing down the Connecticut. Their federal remains untouched. So you really do want to make sure you're tracking it for both.
Is the contribution pre-tax and is it based on all employee earnings, including longevity payments, or is it just based on earned income?
Great question. We use the same definition as they use for developing the FICA, right? So, which is what you use for determining somebody's Social Security contribution. We did that deliberately because payroll systems are already developed to calculate FICA. So anything that goes into FICA would go in, generally speaking, longevity and things like that would count. So would payment for extra duty, right? That goes in because that's earnings. Reimbursements do not. If you have to reimburse somebody because they bought lunch for the basketball team, that's not a FICA wage. So that's part two. Part one is it is after tax. The contribution does not lower the FICA amount. It does not alter their Social Security obligation. So you run the number for determining what their FICA wages is for purposes of Social Security. Say that number is 42,000. You use that number to determine their Social Security obligation. You also use that number to determine their paid leave obligation. Employees who do itemized deductions could consider their deductions, their CT paid leave contributions to be a state or local tax. If you really want to get into the SALT tax stuff, we encourage folks to talk to their payroll tax advisors about that.
Is the pay when scheduled in place for unpaid school breaks?
No, right? So this is what I talked about at the very end of my slides. We only pay if the reason you are not working is because of your leave reason. If there isn't a scheduled school break, say there's a school that has a week off in April, or if nobody works in July, then we will not pay during those times because the reason you're not working is because the school is shut down as opposed to because of your own independent personal leave reason.
If we have an employee who is a plumber and certification is required, are they to be excluded even if other members are covered under the same collective bargaining agreement?
Great question. So when we talk about certification, we mean specifically certification under Chapter 166, which is part of the State Department of Education's set of statutes. It's the statute that's titled, I think, Teachers and Superintendents. We mean specifically educator certifications. We know that there are certain titles in school systems like school psychologists, speech pathologists that are required to be certified by the State Department of Education. They're who we're talking about. Plumbers, bus drivers, right? You might be required to have a commercial driver's license and be certified by the Department of Motor Vehicles. That's not what we're talking about.
What about temporary workers such as coaches and substitute teachers? Are they also subject to this?
I'm giving you the classic lawyer answer of it depends. If they're required to have certification, like a long-term sub could be required to have certification, then they are excluded. If they are not required to be certified, they are in. One handy way to think about it, it's not official because it's not in the statute, but just in practice. We know that in order to be a member of teachers' retirement, administered by the Teachers' Retirement Board, you need to be in a position that requires certification. So folks who are covered by TRB are most likely required to be certified and therefore not in our program. Folks who are not eligible for TR benefits through TRB most likely are not required to be certified and therefore are out of the program or in our program. General rule of thumb, not 100% in all cases. But again, we're really looking at what do you require? I know that there is something that you can get permission from the Board of Education to temporarily allow a non-certified worker to fill a position that would be required under normal circumstance by a certified teacher. In that situation, the position requires certification. There's just a separate statute that allows for this exception. We would treat those folks as being in a position that requires certification.
Based on the new hours requirement under federal FMLA, our paraeducators no longer qualify for federal. We have someone currently using federal FMLA through November because they qualified with 950 hours. But will we need to switch them to Connecticut FMLA on October 1st?
Yeah, so the background for that question is actually, it was a state law. There was a state law that said school paras could qualify for leave that is equivalent to federal FMLA, but with fewer hours. So instead of needing 1,250 hours, they needed 900 hours. It was always a state leave because the federal FMLA has always been 1,250 hours since the 90s when it was first enacted. So they never actually had federal FMLA. They had FMLA pursuant to a Connecticut statute. That Connecticut statute is changing as of October 1st. I would urge you to reach out to Department of Labor using the email address I provided or the phone number I provided to ask them specifically what they would advise you to do, because it's the sort of interaction between the Connecticut law that provided a different hourly work requirement but made FMLA available. It was a Connecticut DOL law, and this new law is a Connecticut DOL law.
We have paras who are paid over 10 months, over a 10-month period, but on equalized pay, can the 0.5% be deducted over the same period based off earnings? And is the 0.5% on all wages, including overtime?
So the 0.5% is on all wages, including overtime. Again, it's really the same. Everything that you would go into the FICA goes into that. And the 0.5% comes out of every paycheck that you issue. So if you issue 10, well, I don't think anybody pays once a month, but so say you issue paychecks over a 10-month period, each of those paychecks, the 0.5% would come out of. If you issue paychecks over 12 months, the 0.5% would come out of those. The end of the year, they're going to pay the same.
We had a couple of questions about school business administrators. So someone asked, are they included? Someone asked about positions that require certification but do not participate in TRB, for example, school business officials.
So the statute says, and that's a great example of why we're being very careful about saying TRB is a broad rule of thumb, but not an official rule. The statute says that if the position requires certification pursuant to Chapter 166, they are excluded. So if there are business administrators who are required to have certification pursuant to Chapter 166, they are excluded.
Okay.
That's really a State Department of Education question about that certification. I know that there were some endorsements that no longer get used. But really, we're just taking advice from Department of Education on who's in and who's out.
Someone asked for clarification on the DSEP question. Would someone with the DSEP would not be eligible for CT paid leave because the position they are filling requires certification?
Correct.
Okay. So someone asked for clarification regarding charter schools. And that is, can you talk about the issues specific to charter schools where there are no unions? Most charter schools are their own school district. It sounds like they are excluded from participating in state paid leave. The only way they can have paid leave is for the school to set up and administer a private plan.
Correct. So charter schools are public school operators. So the employees who are not required to have certification are covered by our program or will be as of October 1st. If the employees of the charter school who are required to have certification want to participate, but they don't have a union, they can't come in through collective bargaining. The only other avenue available is this avenue, which is the private plan option. Any employer who's covered by Connecticut paid leave can apply to Connecticut paid leave for permission to offer their workforce the equivalent or better benefits through an approved private plan. So that is an option for charter schools, but then the requirement is that the covered employees have to vote to approve the private plan. So you'd have to put it to a vote of all of your workers and say, hey, we'd like to do the private plan option. That means everybody gets to come in. You'd have to do a vote of all the workers, and then you could apply to us for approval. There are about 16 or 17 different insurance companies that offers paid leave private plans. You have to get a permission from us. You have to do the employee vote, then you get permission from us. You submit your application with your documents showing that it is in the approved template, and then you'd go on your way, and then you would be the one administering it, or your insurance company. Jess has put information in the chat with some links to the private plans, but that is an option for charter schools.
If we have an employee starting federal FMLA on 8/25 and they are eligible for CT FMLA on 10/1, do they get an additional 12 weeks beginning on 10/1?
Yes. So they will not start drawing against their Connecticut FMLA until 10/1. So even if they've been out before, this 10/1 is a new entitlement. On 10/1, they get the new entitlement.
We just have a couple more that I think we can get through in these last 2 minutes. An employee who holds multiple positions, one being a certified teacher and another being a coach or after school duty, would they pay the deductions on the non-certified positions?
So I'm hesitating. I can tell you how the state handles this, but I would also encourage you to look at your own collective bargaining to make sure that what we do is also an option for you. For the state, because in the state, employees who are in a union or don't participate, but non-unionized workers do. So for us, if their primary position is unionized and they have a secondary position that's non-unionized, they don't participate in the program at all. If they are in a position where their primary position is non-union, but they have a secondary position that is union. They participate in the program, but only to the extent of their salary in the non-union job. The state has this because that is how they've handled similar issues going back years, and it's kind of been approved through collective bargaining. So I think each of your schools would need to consider kind of how you've dealt with such bifurcated jobs, and then move accordingly, and then just let us know.
And the last question, if Connecticut FMLA and federal FMLA are denied, but the employee still takes a leave of absence, can they still apply for Connecticut paid leave?
Yes, they can. We do not provide job protection. We provide money. And there might be people who are not eligible for either federal FMLA or state Connecticut FMLA, but are eligible for our program. So we can give them money even if you are not holding the job for them.
And we just got one more that came in. Where in chapter 166 would we find a list of positions?
I so very, very, very much wish that in a chapter there was a list of positions in chapter 166, but there is not. But if you go to the state education department's website and you look at their pages on certification, um, they have a page on endorsements. In order to be endorsed, you have to approve. This is what they've told us. In order to be endorsed, you have to first have certification. And that endorsement list lists all these job titles. So that's what we've been using. But again, you should know who's required to be certified because you have to make sure that you're complying with Department of Education regulations. So that part should be familiar to you. And then you just use that information to apply to carry that information over with our program.
All right. You got through all the questions, Erin.
All right. Well, thank you all for your time. Thank you for your patience with my little disruption there. Again, we will be sharing the slide and the video, and we are creating an FAQ document. And please check out our website for more information. Hope you all have a good afternoon.